do have skills that make me a nightmare for people like you.
Kua tūwhera tēnei nohoanga a te komihana roera. The sitting of the Royal Commission is now open.
I am Anand Satyanand, Chair of the Royal Commission into Abuse in Care. My fellow Commissioners, Judge Coral Shaw, Ali Muamua Sandra Alofivai, Dr. Andrew Erueti and Paul Gibson, join me in welcoming everyone to this important public contextual hearing. This includes those present in our hearing room here in Auckland, as well as those joining by live stream from throughout the country on the Royal Commission's website, Abuse in Care. Today's event, which will proceed for the best part of the next 2 weeks, will involve the attendance of a great many witnesses, notably survivors, and is one of the main streams which will inform the views of the Commission as time passes. Material from these sessions will join the concurrent streams of research, of private sessions with individual survivors, of roundtable discussions, and the many aspects of community engagement undertaken by our staff and the work of our communications people. I would like to acknowledge, as we start the prodigious work over a lengthy period by our legal team, by our Māori Partnerships Directorate, by our survivor liaison staff, and those responsible for logistics. Everyone has been looking forward to this moment for several months. May I then invite you, Mr. Mount, in a short while to make an opening initial statement as Counsel assisting the Commission, but after you have announced your presence with your colleagues, I'll invite any other Counsel who are appearing to register their appearance should they desire to do so. Mr. Mount.
Ata Mārie, e te tiamana, tēnā koutou, e nā komihana, tēnā koutou katoa. Simon Mount is Counsel appearing together with Ms. Beaton and Ms. Haronga, appearing as Counsel assisting.
Tēnei
Thank you, Ms McKechnie. Thank you, Council. That seems to deal with appearances of Council. Might I then invite you, Mr Mount, to make an initial statement as Council is assisting the Commission.
Thank you, Mr Chair. Tēnā koutou katoa. Nā tātou, mahari mai nei, runga, karanga, o tēnei kaupapa, ngā mahi nui, kei mua ia tātou. I acknowledge all of us here who are brought together by this important and significant kaupapa and important work ahead. A moment ago I appear with Ms Beaton and Ms Haronga as Council assisting the Commission. Over the course of the hearing we will be joined by other members of the Council assisting team who have worked with the witnesses to prepare this evidence for the hearing. They include Hannah James, Chris Merrick, Julia Spellman, Ruth Thomas, and we've also been assisted by Rachel Opie and Andrew Mobley, two human rights specialists who have been engaged by the Commission. I begin today by acknowledging mana whenua, survivors including those who have passed, members of our Survivor Advisory Group and our ambassadors, those participants who have been granted leave to appear, those who've already contributed to the work of the Royal Commission and who are preparing to do so. And in particular, I acknowledge those who worked tirelessly to shine a light on these issues and to bring about this inquiry. I realise that for them, this day has been a long time coming. The purpose of this opening address is to summarise the evidence that we will be hearing over the course of the next 2 weeks, and to explain how this hearing will fit in to the overall work of the Commission. As you know, the terms of reference of this Royal Commission are extremely broad. They will make this inquiry broader in scope than any of the other similar inquiries overseas. Under the terms of reference, the inquiry is required to consider not only sexual abuse, but also physical abuse and neglect. We are required to consider not only the abuse of children, but also abuse and neglect of vulnerable adults. And we are required to consider abuse and neglect in a wide range of settings, from children's homes, care and protection residences and youth justice facilities, to schools, health camps, psychiatric institutions, and facilities for the care of the disabled. We are also required to consider abuse in the care of faith-based institutions, including a wide range of churches and other faith-based organisations, and a wide range of settings. For example, the inquiry has made it clear that we will consider abuse by a member of the clergy in a private home if that abuse was connected to the relationship of trust and care created by the position within the clergy. Without wanting to oversimplify things, there are perhaps 3 key questions on which the inquiry is required to report. They are, first, what do we know about the abuse and neglect in care that has happened in the past, including its nature, why it happened, and its impact? Secondly, how can we prevent abuse in care from occurring in the future? In other words, what systems should we have in place to protect children and vulnerable adults from abuse and neglect? And thirdly, how should redress be delivered for those who have suffered abuse and neglect in care? As Commissioners, you have made it clear that you see your work being guided by 8 strategic pillars, or PO, and you've explained those very clearly at the previous hearings of the inquiry. And those strategic pillars, or PO, are strongly reflected in the hearing that we start today. I want to turn to give a bird's eye view of this hearing. It is the first substantive hearing of this Royal Commission. We have described it as a contextual hearing because its purpose is to place the work of the Royal Commission in context. This hearing will give a preview of some of the topics that the inquiry will be considering in more depth in future hearings and in investigations across the life of the inquiry. This hearing will provide a starting point or a base for the inquiry, rather than being the final word on any of these topics. For that reason, we do not expect that this hearing will involve extensive cross-examination or the resolution of contentious issues. This hearing is an opportunity to listen and to learn in a preliminary way from those who have experience of the matters in the terms of reference. After each witness gives evidence, those with leave to appear will be able to ask for permission to question the witnesses. It will be up to the inquiry to decide whether to grant permission, and if so, what topics may be covered. Because this is a preliminary contextual hearing, I expect that many participants will decide not to ask questions. But in this hearing, no one will be considered to have accepted evidence merely because they don't ask questions. In any event, the inquiry has made it clear that there will need to be very good reasons before questions are allowed of survivor witnesses, and any topics to be addressed to survivor witnesses may be put through counsel assisting if that is more appropriate. Importantly, all participants can be reassured that the inquiry takes very seriously its duty to be fair. In keeping with that, several participants have been granted permission to read short statements at this hearing. Again, the lack of questions from either the Commission or other participants should not be taken as acceptance of any of the matters contained in those statements. While we have tried to address as much of the terms of reference as we can in the evidence in this hearing, it isn't possible to be complete, and there will be gaps to be filled in future investigations, hearings, and with the inquiry's other tools, including private sessions and research. We expect to hear from 29 witnesses over the course of the next 2 weeks. Their evidence will fall broadly into 7 themes. They broadly track the strategic pillars that I mentioned a moment ago. This hearing, the 7 themes are: first, the survivor voice, including the nature and extent of abuse suffered. Secondly, Te Ao Māori, the Maori dimension of abuse and care in New Zealand, as well as the Pacifica experience. Third, abuse in the care of faith-based institutions. Fourth, the societal backdrop, including the reasons why people have been placed in care in the first place. Fifth, the impact of abuse and the experience of those seeking redress. Sixth, the road to this Royal Commission, including the work that brought these issues to attention in the first place, and the work that has highlighted the need for this inquiry. And seventh, the future, including at this early stage, the hopes that our witnesses have for this Royal Commission, and the ways in which they believe it will be possible to transform the way that we care in New Zealand to address the specific questions in the terms of reference. It will be obvious that these 7 themes are not hard-edged. They overlap with each other in many ways. Some of the witnesses will concentrate on just 1 or 2 of the themes, while some may speak to all 7 of them. On the inquiry's website, there is a document that summarises the main aspect of each witness's evidence. That can be found in the public hearings section of the website, and I won't go through the witnesses one by one now. Instead, I will summarise very briefly some of the evidence that I expect we will hear under each of the 7 themes I've just mentioned. Survivor voice. First, we will hear from witnesses who have direct personal experience of abuse and care. They are Keith Whiffen, Arthur Taylor, Rawiri Baratini Karina, Fete Taito, Robert Martin, Dallas Pickering, Beverly Wardle Jackson, Anna Sophia Coleman, and Mike Leddingham. They will talk about the abuse and care of children and vulnerable adults, including sexual abuse, emotional and physical abuse, and neglect. In many cases, they will talk about this happening frequently to large numbers of children and with no effective steps to prevent it. The evidence will cover many different settings, including residential homes, foster care, psychiatric facilities, religious schools, and facilities for the disabled. As we hear that evidence, it will be important to remember that the passage of time means we can no longer hear directly from the children who suffered that abuse. Instead, it has to be reported to us by the adults that those children have become. And while much of the evidence will focus on the childhood experience, in the course of our inquiry, we will also hear about the abuse of vulnerable adults and those with disabilities. Impact of abuse and responses by way of redress. All of the witnesses I have just mentioned will also talk about the effect of the abuse and neglect on their lives. In many cases, they will talk about their attempts to seek redress or justice for what happened to them. For some, it was possible to achieve that. For others, their experience in trying to achieve justice has been extremely difficult. For some, the setbacks in trying to achieve redress have been almost as bad as the initial abuse. Sonia Cooper and Amanda Hill are two lawyers who have acted for more than 1,000 people seeking redress for abuse and care. They will describe more than 20 years' experience in dealing with those cases and the enormous challenges they have faced. Michael Sweeney and Charlene Rapsey are both psychologists who will explain the impact of abuse and neglect on children from a psychological point of view. Many of our witnesses will describe the care to custody pipeline, the fast track that many survivors experienced from abuse and care to imprisonment. Arthur William Taylor is obviously extremely qualified to talk about that, but many of the witnesses from Keith Whiffen to Elizabeth Stanley will also describe this pipeline. Tau Māori and the Pacific experience. Tomorrow we will have the first of our witnesses with a specific focus on the Māori dimension. We will hear from Dr. Moana Jackson, Dr. Alison Green, and Dr. Rawiri Baratini Karina. It is well known that Māori have been placed into care and who have experienced abuse at greater rates than non-Māori. It is essential that this inquiry confronts those aspects of New Zealand's history. Now, I acknowledge the presence today of Annette Sykes, who has been granted leave to appear on behalf of a number of claimants in the Waitangi Tribunal. In this way, the inquiry recognises the vital importance of hearing directly from Māori in accordance with the Treaty of Waitangi. As well, Mr. Fete Taito will describe his experience as a Samoan New Zealander and the abuse that he experienced while in state care as a child. Several witnesses will address the broader circumstances that have contributed to abuse and care and the placement of people into care. These include Professor Elizabeth Stanley, whose book The Road to Hell, State Violence Against Children in Post-War New Zealand, compellingly tells the story of 105 New Zealanders who experienced abuse and neglect in care as children. She will provide an overview of that abuse, including the daily degradations that children experienced in many institutions and the structural framework that enabled that to occur. Dr. Oliver Sutherland will give his perspective on the societal background, having spent 15 years campaigning and advocating on behalf of many children in state care in the 1970s and 80s. Sir Kim Workman will give his account, having begun as a police youth aid officer in the 1970s, and regularly visiting state care institutions in that time period. And he will also give his perspective on some of the major changes to the law throughout the 1970s and 80s in youth justice. Dr. Bridget Murfin-Veitch will give evidence about the abuse and neglect of people with learning disabilities in state care between the 1950s and 1990s, and the broader societal and systemic factors that allowed this to occur. Dr. Hilary Stace will provide a disability perspective on these topics. Her evidence will address institutionalisation of disabled children from the 1950s onwards. Mary O'Hagan will provide historical context for abuse in the psychiatric system, including as it relates to the Treaty of Waitangi. Dr. Anne Else will talk about the state's role in adoption and its role in abuse in that context. Abuse in the care of faith-based institutions. Professor Desmond Cahill and Dr. Peter Wilkinson were both ordained as Catholic priests before resigning from the priesthood in the 1970s. They will summarise what was learned in the Australian Royal Commission into institutional responses to child abuse, to provide a roadmap for understanding the phenomenon of sexual abuse of children and vulnerable adults in religious institutions, particularly the Catholic Church. Michael Eddingham will describe the abuse that he and his two brothers experienced at the hands of a priest while students at a Catholic school in Auckland. At the road to the Royal Commission, Judge Henwood was the chair of the Confidential Listening and Assistance Service, which ran from 2008 to 2015. Over that 7-year period, the Confidential Listening and Assistance Service heard from more than 1,100 survivors of abuse. She will summarise what she learned and how this became an important part of the call for an independent Royal Commission into abuse and care. Rosalind Moonen was New Zealand's Chief Human Rights Commissioner from 2001 to 2011. She played a considerable role in paving the way for this Royal Commission during her time at the Human Rights Commission. She will talk about the efforts that were made while she was Chief Commissioner to bring the issue of abuse and care to the attention of the wider New Zealand public, and she will explain why she became convinced that a Royal Commission was essential. Aaron Smale is a freelance journalist with experience of state intervention in his life. He has written extensively on the topic of abuse in state care, particularly as an issue affecting Māori. He will reflect on his work to date and what he learned from the numerous interviews he has conducted into this topic. Almost all the witnesses will, in one way or another, describe their thoughts about how we could do better to prevent and respond to abuse in care. Judge Andrew Beecroft, the current Children's Commissioner, will not only describe his role and the work carried out by his office, but we'll also talk about the future and, in particular, his views about the way in which this Royal Commission might approach its task. The three witnesses scheduled to be heard today are Judge Carolyn Henwood, Keith Whiffen and Arthur Taylor. I've already very briefly summarised their evidence, and rather than attempting any further summary, it is appropriate that I will shortly simply call Judge Henwood as the first witness for this Royal Commission. But before I do that, I will just briefly address some housekeeping matters. We will begin each day's hearing at 10 a.m, unless there is a particular reason to depart from that timing. Our standard adjournment times may need to be varied according to the needs of witnesses and any other requirements, but typically we will have a morning adjournment at around 11:30 and lunch between 1 and 2:15. Our proceedings will be live streamed, as the Chair has already mentioned, but there is a 5-minute delay. And the purpose of that 5-minute delay is as insurance in case anything is inadvertently said which might breach, for example, a suppression order and which ought not to be broadcast. If any counsel present hears something which they believe ought not to be broadcast on the live stream, they can either let counsel assisting know, and we will draw it to the attention of the chair, or they can draw it directly to the attention of the chair. There will be a transcript available at the end of each day, which we expect to be a full transcript of the day's proceedings. So anyone wanting to monitor the proceedings of the Royal Commission will be able to watch live with the 5-minute delay, or read the transcript at the end of the day, or both. The Commission does have the ability to make non-publication orders in relation to any material that requires such an order. And from time to time, either a member of the council assisting team or other council may ask for non-publication orders to be made over particular material. Finally, and before I call Judge Henwood, I understand that leave has been granted to the Crown to make a short statement at this time, and I will end my address at this point to allow the Crown to make their short statement. Nō reira, tēnā koutou. Kia ora tātou katoa.
Thank you, Mr. Mount. Ms. Aldred, is it your wish to express a statement on behalf of the Crown at this point?
Yes, thank you.
Please proceed.
E te rau rangatira, e te mano roimata, e arahi ana i tēnei kaupapa nui whakaharahara. Tēnā koutou, tēnā koutou, tēnā koutou katoa. On behalf of the Crown, I acknowledge the Commissioners, the Survivor Advisory Group, all those who will speak at this hearing, and all survivors and their advocates here and who are watching the stream broadcast. I appear at this contextual hearing to listen to the witnesses who will give evidence to the Commission and to deliver a short statement on behalf of the Crown agencies regarding the Crown's engagement with the Royal Commission. Caring for children and vulnerable adults is a vital and valued responsibility. Societies are judged by how well they care for their most vulnerable members. It is a responsibility of government to protect the vulnerable from harm and to promote their welfare. At times, we have failed in government as a society and sometimes as individuals in the vital role of protecting our most vulnerable. Our country needs a thorough and open investigation to help bring failings to light. It is important to hear from those who were wronged, to learn from what they say, and to make the changes needed for New Zealand's care system to be stronger and safer for everyone. The Crown acknowledges that Māori have been heavily impacted by the state care system. We need to understand why Māori remain overrepresented in state care and how this has affected generations of whānau, hapu and iwi. The Crown welcomes the Royal Commission's extensive examination of historical abuse and neglect in care and acknowledges the events that have led us to this point. The Crown is not here today to make any statements or claims that might be seen as preempting whatever emerges from the Royal Commission's hearings and investigations. Rather, I will simply explain how the Crown will engage with and respond to the Commission and the spirit it will bring to its participation in this important role. I have been asked to assure the Royal Commission that the Crown is determined to do what it can to help the Commission deliver meaningful outcomes for historic abuse survivors, along with applying any lessons that are relevant to today's care systems. This means backing a process that ensures survivors are heard and feel heard, a process that allows harm to be acknowledged and reconciled. In particular, it means recognising and respecting the experiences of Māori and disabled peoples, two groups that are highly involved in and very affected by the state care system. How will the Crown achieve this? The starting point has been committing the many arms of the state that play a part in the care system to a common set of principles guiding all aspects of the Crown's engagement with the Royal Commission and survivors. These 6 principles were agreed by ministers in Cabinet and issued in May this year as the core of a paper setting out the approach the Crown will bring to the Royal Commission. The principles are a firm undertaking and the Crown expects to be held to them. They aim to ensure the vulnerable are heard and valued and that the inquiry process is respected and supported. They guide government participation in hearings and investigations, as well as the government's broader support for the Commission's work. The principles are manaakitanga, that is, treating people with the compassion, fairness and respect that upholds the mana of all those involved. Openness, being receptive to new ideas, to reconsidering how things have been done in the past and the way agencies operate now. Transparency, sharing knowledge and information held by the Crown, including the reasons behind key actions. Learning, listening attentively to survivors, learning from the Royal Commission and using that information to improve systems. Being joined up, agencies working together closely, helped by a dedicated Secretariat and Chief Executive Sponsoring Group to make sure government engagement with the Royal Commission is coordinated and that resulting actions and recommendations on recommendations are collectively owned. Meeting obligations under Te Tiriti o Waitangi, honouring the treaty principles, meeting Crown obligations and building a stronger Māori-Crown relationship through the way the Crown operates and behaves during this process and after it when implementing its lessons. Many people had experiences as children or vulnerable adults in state care that destroyed their trust in government. The Crown acknowledges that and intends to show its commitment to transformation by adhering to these 6 agreed principles. In hearings, the Crown will take care to ensure that what it says and how it is said upholds the mana of survivors. I have been speaking about the Crown as a single body, but the Commission will understand that it is a collection of agencies and institutions that have changed over time. The historical picture is complex and fragmented, spread across the health, education, social welfare and justice systems. The nature of state care, the organisations and roles within the system, shifted over the half-century from 1950. The specific names, structures and sizes of the organisations changed, but remained a diverse group from 1950 to 1999 and on to today. A timeline listing major organisational and legislative changes will be submitted to the Royal Commission, and the Crown would welcome the publication of that timeline to help provide clarity on how the elements of the state care system have changed over time. Partly because of the many structural changes to the care system, record keeping was, at times, patchy. It is acknowledged that over the decades, agencies have been inconsistent record keepers. The Crown will provide all information that is relevant, that is as complete and well organised as possible, and will do its best to track down all relevant records and supporting material. The Crown will make the relevant staff available to attend hearings. Over the years, particular events or institutions have been the subject of targeted inquiries that led to specific changes. The Crown welcomes this opportunity to step back and look at the whole picture. The Royal Commission of Inquiry is a chance for New Zealand to understand and address what occurred across the whole of the care system. The Crown today is different to what it was 70 years ago, and it will be different again in 70 years' time. Over the past 2 decades, the Crown has made changes to improve safety, protection, and the availability of redress within the system. There have been efforts to improve quality and professional standards, including stronger systems for reporting concerns and misconduct, better vetting and approval of education and social workers and providers, and the work currently underway to set up stronger, independent monitoring for the Oranga Tamariki system. In the mid-2000s, the Crown introduced a structured historic claims approach involving the Ministries of Social Development, Education and Health. Over 4,000 claims have been received to date, with approximately half of these settled so far. Work on reviewing and improving access to and processes for redress of historic wrongs is ongoing, and the Crown looks forward to what can be learnt from the March 2020 redress hearing that will focus on that particular area. Improvements to all of these institutions and systems are ongoing, but the Crown recognises that it needs to do more. It will welcome the Royal Commission's findings that contribute to further change and better care for the vulnerable. In short, the Crown is here to listen and learn, to provide the Commission with the information and evidence it needs to help explore the past, to see what it means today, and to make recommendations for what can be done to improve the future. O te rā, tēnei te mihi a te taringa ariari, ki ngā taonga o te kaupapa nei, rauranga tira mā, tēnā koutou, kia ora tātou katoa.
Okay, ngā mihi, thank you, Ms Aldred.
Kia ora.
We are now at a point, Mr Mount, where you are going to call the first witness. Will it suit things if my colleagues and I adjourned briefly to enable those arrangements to be set up?
Yes, thank you very much.
Or we'll do so.
Yes, thank you.